So let us discuss 23 July 2015 newspaper. So the one important article is related to the judiciary and the role played by the judiciary during emergency, and from there it was traced towards today's judicial activism. During the emergency, in ADM Jabalpur vs Shivkant Shukla case, it has been clearly the Supreme Court has adjudged that if any person is detained under the Maintenance of Internal Security Act, that is MISA Act, he could not approach the judiciary if their fundamental rights are violated. So whenever in those days before the 44th Amendment Act, the President of India, he can suspend any of the fundamental rights, including the rights under Article 21. When Indira Gandhi declared emergency, the President of India declared emergency. Article 21, the rights under that are also suspended under Article 359 of the Constitution. Now in this context, a person who is detained under MISA Act, so now can he take a recourse to the conditions of his detention? So under the constitutional right, that was come before question. Now when the Supreme Court has said he cannot approach the court for the violation of the fundamental rights, it failed to exercise its independence and also failed to exercise its right of judicial review. So this is in the history of the Supreme Court, we can say it as an institutional failure. And added to that, only one among the 5 judges opposed to this, and he was Mr. Khanna, J. Khanna, he was rewarded in such a situation where, as per the seniority, he was supposed to become the Chief Justice of India. Mr. Beg was made as the Chief Justice in the place of Mr. Khanna. So it shows that the Supreme Court, as the protector of the fundamental rights, has failed. Now in this context, Mr. Jagadish Bhagawati, who is the pioneer of the pill, he has publicly apologized for this judgment, which he considered as a historical error. Now in this context, so the author argues that the judicial activism which we are seeing now, it is in a way the judiciary is trying to correct its past mistake through the radical approach of judicial activism. So this radical nature of judicial intervention and sweeping orders of the judiciary are becoming all pervasive across the entire executive and legislative domain. So it is not good even for the judiciary or to the other organs of the government. That's what is the argument is. Now in this context, let us see what are the negatives of the judicial activism. We know that the judicial activism has brought much of the progressive legislation to the country, and also it has become an answer to the failures of the executive and legislature. So the pill, it has become a major source of judicial activism. But however, pill itself is criticized as, that is, private interest litigation or publicity interest litigation. It has been criticized majorly as. On the other hand, on what basis the judiciary is selecting the cases? There is no criteria for the judiciary to take the cases into its own hands. It means there is a lot of arbitrariness that is prevailing. And does the judiciary has the capacities and technicalities to undertake these particular matters? For example, CNG is a proven fuel over the other fuels. Is this technically proven when the Supreme Court has taken that particular judgment in the Delhi case? It means the Supreme Court did not have the necessary technical expertise to understand the nitty-gritties of the growing technology, and also it did not have the necessary capacities to enforce what it says. So in this context, the cascading effect, so the Supreme Court's this particular thing, it has swept across the entire judicial spectrum. It means high courts are leading to overreaching their authority. and even tribunals, everyone they are outreaching their authority. So a cascading effect has been spelled out in. If you take about the National Green Tribunal recently, it has said that all the vehicles greater than 10 years diesel vehicles have to be abandoned from the roads in Delhi. And similarly petrol vehicles. What are the consequences of that are not been properly estimated. So it means automatically it has assumed that any vehicle is greater than 10 years, it is unfit for moving on the roads. So now, and the second, it is also talking about congestion charges. All these are the decisions that are meant for the executive. So it means whatever the legislature or else whatever the executive is supposed to do, the judiciary and judicial bodies are taking up that. And next is, because of this, let us see one thing. Does the judiciary has legitimacy to do that? Now, judiciary has appointed judges, that is the first case. And this is the most unaccountable institution. The checks and balances are being taken totally out, and the judiciary became a prerogative within itself. It means that there is accountability of the judiciary to the various institutions is very minimal. The checks and balances created within and outside the judiciary, probably they are not appropriate. So an appointed, that is unelected, unaccountable body taking the much of the governance into its hands, it is dangerous to the country. And it is also undermining the legitimacy of existence of the other institutions, which is going to make the situations much worse. On the other hand, the judicial activism, it is taking away much of the time of the judges, and already the pending cases are being kept aside, or the pending cases are being piling up over a period of time. Now in Supreme Court itself, almost 61,000 of cases are pending over there. 61,000 of the cases, which is too huge. So from this we can say that, what is the conclusion I can bring in? Yes, judicial activism, it has provided for independent image of the judiciary, there is no doubt about it. It also gave us some certain social progressive legislations, but it has come at the cost of quality, discipline, and the constitutional role of the judges getting redefined. So it means, yes, it has done some good, but that good has come at certain cost. That's what is the conclusion which I try to take again for the judicial activism. And next is the biometric data. Nowhere with regard to the Aadhaar, the biometric data is being mentioned. But however, the biometric data is quite a personal data, and there is no legislative approval for that, and government is accepting it. Automatically it is going to violate the privacy of the citizens, and it may be used by the state to spy its own citizens. In this context, the right to privacy is one thing which is declared under the right to life, which the government argues contrary to it. So this is what is the petition which has come before the Supreme Court. Let us see, which has been referred by Justice Chalameshwar to the higher bench. Let us see what it will happen now. So what is the status of right to privacy? If there is a clarity on this status, then to what extent Aadhaar is legal in this country? The big data, how it is going to kill our privacy, already I have discussed many a times. The next thing is the mercy petition with regard to Akub Memon of 1993 Mumbai serial blast. Understand, the capital punishment, the Supreme Court has clarified that it has to be rarest of the rare cases. Does this fit into this rarest of the rare definition of the Supreme Court? That is one thing, but the Supreme Court did not define what constitutes to be a rarest of the rare case, that is another case. The second thing is the ideological opposition to the capital punishment comes from the logic of human nature. The humanity cannot be, or else one life of one individual cannot be taken away by the other individual. So the system cannot take away the life of the other individual. That has led to the abandonment of the capital punishment. That is what is ideological position. Third thing is there is a good chance of error of judgment. Recently, if in United States of America, the president has signed a mercy petition for many of the prisoners. So here, I have discussed in the class, if you can remember, that independence project, I think. So I'll try to give the correct name of it. In that project, more than 300 of the people, they are wrongly convicted. It means error of judgment can take away the life of an individual, where India is not an exception. So in this, these are the arguments that go against the capital punishment. And is capital punishment, it is derived from the principle of deterrence or deterrence effect. So the punishment has to be as severe as possible to have a deterrence from committing a crime. But deterrence and reform, are they intricately connected or not, is one more question which we have to answer over here. So can deterrence automatically, will it lead to a reform? Or does the law has enough deterrence? The proportionality is one thing which we have to understand. The punishment which has to be given proportional, it has to be proportional to the crime committed. After the proportionality, more than the punishment, the promptness of the punishment and investigation, that matters the most. That has a greater deterrence than the size or volume of the punishment itself. So that is what is the thing we need to understand. And the next is the prohibition which is going to come up, which the electional promises are being made in Tamil Nadu. So there are some things we need to understand. The prohibition was promised under DPSP. Now, anyway, the prohibition, if it has to be brought on the intoxicating drugs, there has to be a collective effect of the, or collective effort of the states. Prohibition historically has failed in isolation. In Andhra Pradesh, in Tamil Nadu, in Kerala, wherever it is, unless all the states come together towards the prohibition, then it cannot move forward. What the people do is, they move to the other states to drink and come. And the second thing is, illicit alcohol will increase in the hooch or something, it will increase in the making. So that will take the more toll of life than this particular problem itself. So there has to be a collective enforcement of the states. And the third thing is, the state governments themselves are not interested in proper enforcement. Because enforcement of prohibition itself is a costly affair. In two ways. One is, the enforcement machinery has to be created. And second, there is a loss of revenue to the government itself. The loss of revenue to the government itself in the form of taxes. So most of the freebies given by the government, they are through the revenue which has come through the enforcement, which has come through the taxes levied on the alcohol and other products. So any prohibition, it has to be associated with a proper check on the illicit production of the alcohol. Second, prohibition has to be collective. And the corruption, it is unnecessarily leading to the corruption. So enforcement has to be strict. And corruption has to be strongly fought against. And the loss of revenues have to be properly compensated. Then only this particular prohibition will be successful. Next one is related to the market. This is a typical market argument. Anywhere state versus market comes up, here whatever is given in the market, this argument is a typical argument argued by the market people. What they argue is, there has to be a free trade where the market has to determine the prices. On the other hand, the MRP, it is incentivizing the abnormal fixation of the retail prices, which is not benefiting either the retailer nor the producer, neither the retailer nor the consumer, because the cost escalation happens from one region to the other region, from the place of the production to the place of consumption. The MRP is not allowing to increase the cost of the good as per the expenses incurred. Because of this, they are making up a price which is maximum possible. It means, for example, a good is produced in Delhi and it is for 10 rupees. It can be best sold for 12 rupees in Delhi. In Guwahati, it can be sold for 15 rupees. So now, What they are doing is the product is being sold at the 15 rupees both in Delhi and Guwahati. In that way the consumer is not getting benefited. And the second thing is this fixation of the price, it is making corruption wherever the regulation of the government exists, there the corruption will be high. And the third thing is many of the products are out of scope of this regulation. If the government has to regulate something, the regulation has to be perfect. And if there are loopholes, the regulation is bound to a failure. So, it means improper regulation leads to corruption, and improper regulation also leads to the failure for or dysfunctionality with regard to the market mechanisms. So let the demand and supply determine the product, cost of the product, rather than arbitrarily fixing by the producer the cost of a particular product. So it's an obsolete practice in the free market economies which India is still practicing. Next is the GST bill. Already I have discussed the GST in very detail for you. Please try to recollect. I forgot the article, date of the article. But however, the amendments are, so the GST was accepted by the standing committee. So now up to 5 years, all the states that are losing revenue will be compensated by the center. And next is center's representation in GST council. It will be reduced from 1/3 to 1/4. And next is GST rate will be capped for 20% for it is a standard rate. 14% for the reduced rate. So these are the things which is already given in this particular box. These are the things you need to look at. And the white coats, generally in the hospitals, hospital acquired syndromes or hospital acquired infections, so not syndromes, hospital acquired infection. Most sources of the hospital acquired infections are what the doctors wear. One is their aprons, their steth, etc. I never remember when I washed my apron. So it means that's a good source of infection for everyone. So thank you very much for the class and all the best.